So it has been a really big week for the Supreme Court, and we think it's very important to cover the Supreme Court, not just to explain what the outcome is so that people who are on the left or right judge the outcome simply based on the results, but to really give you an understanding of what this very powerful entity in the United States is doing. We covered one decision that they issued earlier this week, which is the decision where they shielded the Biden administration from any sort of constitutional review. And in that decision, Amy Coney Barrett and John Roberts joined with the three liberals. It was Alito and Gorsuch and Clarence Thomas in the minority. Oh, it was Brett Kavanaugh, Amy Coney Barrett, and John Roberts, who joined the three liberals for a 6-3 ruling that said the plaintiffs don't have standing there. We covered that in depth the other night. Also today, they overturned, the court did, by a 6-3 ruling with the 6 conservatives on one side, the longstanding doctrine called the Chevron doctrine, which basically, though it sounds boring, instructs courts to defer to the interpretations of congressional law, whatever agencies decide the law means. And the court has said there's no reason for judges to give deference to, say, the EPA or the FBI or any other executive branch agency there to regulate. It's not their job to interpret what Congress meant. It's Congress's job to pass a clear law. And if they don't, if there's ambiguity, then the courts are the place where those disputes should be determined. It really has the effect of taking a lot of power away from the administrative state, the unelected administrative state, and handing it back to Congress and to some extent to the courts. On July 1st, on Monday, the court will decide its last case, which is whether or not President Trump enjoys immunity from any kind of prosecution for acts undertaken as president. That will obviously have a big impact. My guess is they will either reject his theory or will send it back to the courts to further analyze certain things, but we'll see how that goes. But they also today overturned the theory that prosecutors had been using in order to take nonviolent January 6th protesters, and even some who use violence, and turn them into felons using an extremely distorted and stretched interpretation of a law that was passed back in 2000 after the Enron scandal. Paul Krugman was on the board of directors of that company, Enron, that turned out to be a gigantic fraud. The whole thing collapsed. And in the wake of the collapse of Enron, they realized that there was a loophole in the law that prevented them from prosecuting the accountants who helped Enron commit that fraud. They prosecuted the CPA firm Arthur Andersen, but they couldn't prosecute the individuals. And so they enacted a law called Sarbanes-Oxley after the 2 members of Congress who sponsored it. And all that law did was say that if you obstruct investigations or official proceedings, you can be guilty of a felony. They had no intention for it to apply to political protest. It was simply designed to prevent people from obstructing ongoing investigations. After January 6th, the prosecutors who were covering these cases were under a lot of pressure to put these January 6th defendants, including ones who used no violence, into prison for a long time. In order to do that, they needed to concoct a theory as to why just entering Congress and protesting can somehow turn you into a felon. And the theory that they used was this wildly expansive interpretation of Sarbanes-Oxley that the Supreme Court today rejected, which means that a lot of those prosecutions of January 6th defendants can be in jeopardy. And the case that Jack Smith has brought against Donald Trump, charging him with felonies related to his conduct pertaining to January 6th, also in part used this theory that the Supreme Court today rejected. The Wall Street Journal back in 2021 explained the following, quote, "To prosecute January 6 Capitol rioters, the government tests a novel legal strategy. As first trials approach, some defendants are challenging use of Sarbanes-Oxley Act to obtain felony convictions and stiff sentences." The problem was these judges were too cowardly, too afraid to rule in favor of January 6th defendants. So almost every judge on the lower court level accepted and approved the prosecutor's distortion of the law. And I've been writing about this going back for many years. Here is an article I wrote in Substack in 2021, where I was describing how Democrats had always pretended to be so pro-defendant, anti-prosecutor, believe in criminal justice reform, and yet when it comes to their political enemies, they're willing to relinquish every one of the claimed beliefs they have about the judicial system in order to ensure that their political enemies go into prison. I talked a lot about how the prosecution of Michael Flynn, which almost every left liberal cheered, used a huge number of prosecutorial weapons and theories that anyone who considered them a criminal justice reform advocate had long opposed. And of course, they didn't care. They suddenly embraced it in order to put Michael Flynn in prison. The same thing happened when cheering the conviction as felons of January 6th defendants under a theory of law that was obviously so distorted, so stretched and dubious, and that had the potential in the future of turning any political protesters into felons, simply because they might have disrupted a proceeding in Congress. And here's what I said in that article when describing specifically what the prosecutors were doing here. Quote, "The most protracted thirst for harsh criminal punishment from Democrats has been directed at those who participated in the protest-turned-riot at the Capitol on January 6. Of the more than 600 people charged with crimes in connection with that riot, only a minority are accused of using violence of any kind. In other words, the majority of January 6 defendants are accused of non-violent crimes. While few people object to prison terms for people who use violence as part of that riot, even though many progressives do object to long prison terms for those who use violence as part of the 2020 Black Lives protest movement, a large number of non-violent protesters face serious felony charges and lengthy prison terms. That nonviolent protesters should not be imprisoned is foundational to the criminal justice reform movement, yet it is nowhere to be found when it comes to the January 6th defendants whose real crime is that they have the wrong ideology. To charge nonviolent January 6th defendants with felony charges has been a serious challenge for federal prosecutors. Since when is nonviolent trespassing a felony? To convert it into one, the DOJ has invented a warped theory about what the Sarbanes-Oxley Act of 2002 was intended to criminalize, insisting that the phrase obstruction of justice provision of that law, intended to regulate Wall Street, somehow applies to the January 6th certification vote at the Capitol. And the irony was, in order to argue that, they had to depict the vote counting on January 6th not as a mere ministerial act, but as an official investigation that Congress is undertaking, where they had the option to reject the vote totals or accept them, the exact theory that Donald Trump had used as to why Mike Pence could reject the totals. So it was always an extremely warped and stretched meaning. We covered it as well earlier this year because an appellate court had finally looked at all these prosecutions and rejected the validity of this theory that the prosecutors had used to put a lot of January 6th defendants into prison as felons. And here's part of what we reported back then in March. Because they weren't engaged in violence. And typically non-violent political protesters in the U.S. are rarely charged, and if they are, they're charged with misdemeanors, but not in the January 6th case. And the way that this was done is so ironic. We've been over this before. I've written articles about it. So you can go, and if you want to really dig into the legalities of what I'm describing here, you can do so. But basically, there were laws that were enacted in the wake of the collapse of Enron, which was a gigantic energy company, Paul Krugman. So we don't need that whole explanation again. I just want to show you that this is something we've been covering for a long time because I have been always very alarmed that prosecutors are just able to invent new laws out of nowhere, and everybody was fine with it because all they wanted to do is put January 6th defendants or protesters into prison for a long time without the slightest regard to whether they actually committed felonies. They were seen as political prisoners, as people that you just wanted in prison at any cost. And because judges were too afraid to rule in their favor, many of them went to prison for a long time as felons under a theory that never made any sense. Here in March 1st of this year was the first glimmer that courts were finally willing to say that this is a theory that had no validity. From the Washington Post, quote, appeals court ruling means that over 100 January 6th rioters may be resentenced. And then it goes on to explain what the court ruled. Now, it was this ruling that went to the Supreme Court, and the Supreme Court decided today by a 6-3 ruling that you cannot turn January 6 defendants and protesters into felons under this interpretation of the Sarbanes-Oxley Act that had been used over and over to throw these people in prison for a long time. And the breakdown of the decision was very interesting. The 6 justices voting to reject the prosecution theory were 5 conservatives: Thomas, Alito, Gorsuch, Kavanaugh, and Roberts, along with Ketanji Brown Jackson, who joined the majority. And she did so and then wrote a concurrent opinion, her own opinion, that was extraordinary in terms of just how straightforward it was in condemning what had been done to these defendants. She has a long track record of being pro-defendant, and rather than suspending her values and judicial beliefs simply because she doesn't like the ideology of the defendant, she very commendably applied her pro-defendant, anti-prosecutor ideology to these defendants as well, because she knew that allowing prosecutors to invent laws to put people in prison who don't belong there will endanger everybody. On the other hand, the 3 justices who formed the dissent were Elena Kagan, Sonia Sotomayor, and Amy Coney Barrett. And she wrote, Amy Coney Barrett, the dissenting opinion. But in reality, she wasn't ruling against the January 6th defendants. She is a pro-prosecutor judge. And so her ruling as well was consistent with her longstanding theory about how to interpret laws, especially criminal laws, that are generally unfavorable to defendants. So it was really an example where at least those 2 judges, Jackson and Barrett, reached a conclusion legally that they knew would displease their political faction. And I think when a judge does that, even if you don't like the result that it creates, that's actually commendable. That's what you want from a judge. That's what every judge swears when they're being confirmed before the Senate that they'll do. Oh, we're just going to apply the law without the slightest regard for the political outcomes. And very few judges do that. And when judges do it, as they both did here, I think it's to be celebrated. Let me just give you a slight taste of why the court ruled the way it did. And in reality, it's a very technical ruling. It's just a question of how to interpret this law and whether it should be read expansively to include behaviors like protesting the Congress on January 6th, and the majority said that it couldn't be. Here's what the majority opinion from Justice Roberts said. Quote, to prove a violation of section 1512C2, that's the provision of the Sarbanes-Oxley Act, the government must establish that the defendant impaired the availability or integrity for use in an official proceeding of records, documents, objects, or as we earlier explained, other things used in the proceeding or attempted to do so. The judgment of the D.C. Circuit is therefore vacated, and the case is remanded for further proceedings consistent with this opinion. On remand, the D.C. Court may assess the sufficiency of all these other charges. So it was a very just straightforward statutory interpretation where they concluded that Sarbanes-Oxley could not be read to turn these people into felons. The much more interesting opinion was what Justice Ketanji Brown Jackson wrote in her concurrence, where she explains why she's joining the majority, the conservative majority, and ruling in favor of the January 6th defendants. Listen to what she said here. I think this is such an important passage, and I wish every liberal who respects and likes her would actually read this to understand what it means to apply a principle irrespective of the political outcome or the ideology of the people whose legal rights you're protecting. This is what she wrote, quote, "On January 6, 2021, an angry mob stormed the U.S. Capitol seeking to prevent Congress from fulfilling its constitutional duty to certify the electoral votes in the 2020 election. The peaceful transfer of power is a fundamental democratic norm, and those who attempted to disrupt it in this way inflicted a deep wound on this nation." So she's saying, like, I see January 6th the way liberals see it. But then she goes on, "But today's case is not about the immorality of those acts. Instead, the question before this court is far narrower. What is the scope of the particular crime Congress has outlined in 18 U.S.C. 1512 C2? That's the law we've been talking about." And then she went on to say this, quote, "In the United States of America," and she's quoting a case here, quote, "men are not subjected to criminal punishment because their conduct offends our patriotic emotions or thwarts a general purpose sought to be effected by specific commands which they have not obeyed. Nor are they to be held guilty of offenses which the statutes have omitted, though by inadvertence to define and condemn." And she quotes a 1943 Supreme Court case there. And then she goes on, "Our commitment to equal justice and the rule of law requires the courts to faithfully apply criminal laws as written, even in periods of national crises, and even when the conduct alleged is indisputably abhorrent. Notwithstanding the shock of circumstances involved in this case or the government's determination that they warrant prosecution, today this court's task is to determine what conduct is prescribed by the criminal statute that has been invoked as the basis for the obstruction charge at issue here. I join in the court's opinion because I agree with the majority that this law does not reach all forms of obstructive conduct and is instead limited by the preceding list of criminal violations." And as a result, she voted to apply this law in a much narrower way than the prosecutors of the January 6 defendants had applied it. Now, similarly, Amy Coney Barrett, who might have surprised a lot of people by voting in favor of a prosecutorial theory used against January 6 defendants, but in reality, she's a pro-defendant, pro-prosecutor, generally a judge who often rules against defendants. She did what you would expect her to do if she were ruling apolitically, which is she, just like Ketanji Brown Jackson gave a anti-prosecutor ruling, Judge Barrett gave a pro-prosecutor ruling. And this is what she wrote. It's a very technical and legal analysis, and that's it. Quote, "This court does not dispute that Congress's joint session qualifies as an official proceeding, that rioters delayed the proceeding, or even that the defendant's conduct, alleged conduct, which includes trespassing and a physical confrontation with law enforcement, was part of a successful effort to forcibly halt the certification of the election results. Given these premises, the case that this defendant can be tried for, quote, obstructing, influence, or impeding an official proceeding seems open and shut. So why does the court hold otherwise? Because it simply cannot believe that Congress meant what it said. The law in question is a very broad provision, and admittedly, events like January 6th were not its targets. Who could blame Congress for that failure of imagination? But statutes often go further than the problem that inspired them, and under the rules of statutory interpretation, we stick to the text anyway." So I think the ruling is absolutely right. I've been arguing this for many years from the beginning, that this law provides no basis for prosecuting January 6 defendants as felons. I am very glad the Supreme Court concluded that way. That means a lot of January 6 felons are going to have their convictions subject to being overturned or reviewed. It's going to make the prosecution of Donald Trump much more difficult, since this is a theory that Jack Smith used, that the Supreme Court has now said is invalid. But I also want to emphasize that although we generally celebrate when judges reach an outcome that we want, sometimes judges are willing to contravene an outcome that they may be politically sympathetic to because their legal reasoning leads them to that conclusion. And that's what we should want in judges. That's what we should celebrate in judges. So I think Amy Coney Barrett is wrong here, but I think it's impressive that she's willing to apply the way she interprets criminal law to reach the conclusion that she reached, even though she's ruling against January 6 defendants. And conversely, I think what Ketanji Brown Jackson did in applying her long-standing interpretation of the criminal law to favor defendants and limit prosecutorial power, even though in this case it ended up protecting January 6th defendants, which she made very clear are people she finds to have engaged in horrific and dangerous behavior. I think that too is extremely commendable. That is what we want from judges, even in the cases where we end up disagreeing with them. So finally, I think it's so important that the courts have been willing 3 years later to set aside all the intense emotion around January 6th, to abandon this idea that we should invent laws or fabricate laws or concoct new and exotic theories to justify putting people into prison because we don't like the politics or the political protest in which they engaged. And every time the court engages in an act where they're just actually interpreting and applying the law and not doing so because of the political outcomes, I think it's something that should be applauded. And in this case, it will have a very significant and I think positive outcome in making clear to prosecutors that no matter how much you hate criminal defendants, no matter how unpopular in the country their cause might be, you do not have the freedom to fabricate or invent new laws on the spot simply to achieve the outcome of putting them in prison because you believe that's where they belong. Thanks for watching this clip from System Update, our live show that airs every Monday through Friday at 7 p.m. Eastern exclusively on Rumble. You can catch the full nightly shows live or view the backlog of episodes for free on our Rumble page. You can also find full episodes the morning after they air across all major podcasting platforms, including Spotify and Apple. All the information you need is linked below. We hope to see you there.